Thank you for inviting me to speak today. I'm the Litigation Director for the BC Civil Liberties Association, and I'm appearing virtually from Vancouver, and I'd like to acknowledge that I'm speaking to you from the traditional, ancestral, and unceded territories of the Coast Salish peoples, the Squamish, the Tsleil-Waututh, and the Musqueam nations. I make this acknowledgement understanding that the history of colonialism and ongoing oppression has led to glaring disparities in healthcare and health outcomes between Indigenous and non-Indigenous peoples. And any public health discussion, including a discussion about MAID, must recognize and then transform this fundamental ongoing injustice. The BC Civil Liberties Association, along with Joe Arve, represent Julia Lamb in her case challenging the constitutionality of the current MAID legislation. As the senator said, Julia was not feeling well enough to speak to you today, but she did ask that I read a statement on her behalf, which I will do now. She writes, thank you for the time and opportunity to have my words heard today during this pre-study. 4 years ago, I joined the BC Civil Liberties Association after the passing of Bill C-14, motivated by the understanding that as it stood, if and when I would apply for MAID, my application would be unjustly denied as not fitting the reasonably foreseeable natural death eligibility category. This exclusion was felt by me immediately, and its reality proposed to me that the prolonged and agonizing suffering of those who are not on a definitive trajectory of death would be left without choices, or to make heartbreakingly terrible ones. At this time, I faced that this could be the state of my future. Out of the fight from Nicole Gladue and Jean Truchon, Bill C-7 acknowledges the truth that reasonably foreseeable natural death is an unconstitutional sole criterion. The decision of this case was also felt immediately, except that instead of exclusion, many Canadians felt heard and respected, for MAID is the individual's choice to make regardless of the timeline of their intolerable suffering. I have heard this firsthand through personal stories shared with me. Now Bill C-7 exists in this moment, containing 3 areas of concern from my point of view. First, the adjournment of my case was based upon evidence that I would now be eligible under the reasonably foreseeable natural death requirement. Worryingly, though, this language has been kept in this bill, yet has had no added or detailed definition, and is being used to differentiate the defining 2-track setup of Bill C-7. This is leaving confusion as to where I personally may fit in, and I fear that the language lacks clarity. I think if dying is struck from the preamble in C-7, it would go a long way to help me and my doctors know that reasonably foreseeable natural death applies to my medical condition. Second, someone who is eligible, meeting all criteria, but is not determined to be reasonably foreseeable in their decline, must confront a 90-day waiting period. I say confront because a 90-day waiting period is a large and looming time frame to be under when suffering intolerably. I have great concern that this criteria might mean for my future if I choose MAID, the last days of life being not something of my choosing, and the drawn-out pain and suffering I may endure because it is not determined as equal to those who are more timely in their matter of dying. A bill that is supposed to be a choice to end feeling trapped and hopeless and unbearable suffering, instead may trap me with an excruciating 90-day waiting period. Third, additionally, someone whose death is not reasonably foreseeable will be denied the waiver for final consent. This is very worrying for me. As you may know, I have SMA type 2, a hereditary progressive degenerative disease that causes weakness and wasting of the voluntary muscles. I experience frequent pain from muscle contractures and suffer from falls and repeated broken bones because of severe osteoporosis. I also have severe breathing difficulties that has led to recurring instances of pneumonia. Because my health is so compromised, there are several reasons why I might lose capacity and be denied my right to assisted death if I cannot waive final consent. After fighting for years for my rights, this is a heartbreaking possibility. Bill C-7 is hope for so many. It must uphold compassion and choice. The pillars of the Carter decision, the human rights of Canadians with incurable, grievous illness and intolerable suffering, matter and should be reflected in this legislation that was ordered to improve on the previous bill that got it wrong. It now must get it right for all of us that were left out. It is also important for me that I say I write these words as a member of the disability community. I acknowledge that when I speak, I have the privilege of speaking for myself, and my testimony is to share my personal beliefs and understanding. I do not share the same viewpoint that some members hold of Bill C-7, and I respect and uphold the diversities and commonalities within this community. There are other members of the community that share my view, some advocating for voices to be heard, laws to be changed, justice to begin, and for the oppression to be not only acknowledged, but be held equal in priority. I believe MAID and the work that is happening and is to be done for and by our community. I do not have to be pitted against each other, but instead exist within their own right, reflecting the needs and diversities of our lived experiences. That was the statement that Julia Lamb asked that I share with you. And I will now continue with some brief further remarks from the Civil Liberties Association. When Julia asked the Civil Liberties Association to represent her in her challenge to the MAID legislation currently in force, we were guided by the principles of the Carter case. I was part of the trial team in that case. It's worth rereading, I believe, the first paragraph of the Carter decision because it sets out what's at stake for sick and suffering people and for physicians who provide compassionate health care. That first paragraph reads, "It is a crime in Canada to assist another person in ending her own life. As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering. A person facing this prospect has two options. She can take her own life prematurely, often by violent or dangerous means, or she can suffer until she dies from natural causes. The choice is cruel." This absolute prohibition on assistance in dying is what led Sue Rodriguez and then Gloria Taylor and then Julia to ask, whose life is it anyway? They're expressing their view of the fundamentally personal nature of the decision to hasten dying and the fact that an individual's choice in dying is critical to autonomy and dignity and also to the value of compassion. There are many aspects of Bill C-7 that are positive and respect the rights and serve the interests of Canadians. Just recently, Dr. Downey canvassed with you these positive aspects of the proposed legislation in her remarks to you, and the BCCLA endorses her submissions. We also accept and endorse the three areas of grave concern raised by Julia, and shortly we will be pleased to provide detailed submissions to the Senate on those points. I am going to focus my remaining remarks on the mental illness exclusion. As you know, Bill C-7 contains an absolute prohibition against permitting people whose sole underlying condition is mental illness from having the choice of medical assistance in dying. The prohibition applies to all persons suffering from a sole condition of mental illness, regardless of whether they are decisionally capable individuals. This absolute prohibition does not comply with the Supreme Court of Canada's Carter decision, and it's therefore unconstitutional. In addition, the provision unjustifiably infringes Section 7, the rights to life, liberty, and security of the person, and Section 15, the right to equality of the Charter. It's important to remember that the Carter decision sets the floor and not the ceiling of what is constitutionally required to respect the rights of Canadians. So this means that while Parliament may extend the rights to assisted dying beyond what the court required, for example, by permitting nurse practitioners to provide MAID and permitting final consent waivers, it cannot restrict those rights. Canada should support human rights and mental health care, but Bill C-7 has the opposite effect. It stigmatizes and abandons those suffering from mental health issues. In the Carter proceedings, the plaintiffs challenged and the court declared unconstitutional the criminal law's absolute prohibition against physician-assisted dying. The prohibition was absolute because it did not permit patients the benefit of being individually assessed for eligibility for physician-assisted dying. It was absolute because it did not distinguish between those who were vulnerable and those who were entitled to choose for themselves. The specific issue of whether those suffering from psychiatric conditions should be excluded from the Declaration of Invalidity was squarely before the Supreme Court of Carter, the Supreme Court in Carter. The court rejected the government's argument that there was no reliable way to identify those who are vulnerable and those who are not. And the court ultimately concluded, this is at paragraph 116, that, quote, it is possible for physicians with due care and attention to the seriousness of the decision involved to adequately assess decisional capacity. The government now asserts that the Carter decision does not apply to those with mental illness, and these assertions rest on a particular interpretation of Carter. It's an interpretation that's been rejected multiple times by multiple courts. In one such application in 2016, in the EF case, the Attorney General argued that the scope of the Carter decision and therefore Carter exemption relief was limited to those with terminal illnesses and expressly precluded those with psychiatric conditions. It lost that argument before the Court of Queen's Bench of Alberta and the Alberta Court of Appeal in a unanimous decision. That legal challenge was brought by EF, a woman who received MAID when a mental disorder was her sole underlying medical condition. And the Alberta Court of Appeal unanimously rejected the argument that psychiatric conditions are excluded. The Attorney General then advanced the same argument that the scope of the declaration in Carter was narrowly limited to a subset of persons before the Ontario Superior Court of Justice in the IJ case. It lost there too, and again, it did not appeal. It also lost the argument in Truchon, and again, it did not appeal. Significantly, as it is something that Canada is uniquely able to do, Canada also did not refer the issue of the proper scope of Carter to the Supreme Court of Canada for an opinion. Instead, it continues to press its argument in the Court of Public Opinion and before senators and members of Parliament. Historically, individuals with mental disorders have been assumed to lack capacity, and they have endured significant injustice as a result. A blanket restriction on MAID for persons with mental disorders dismisses the magnitude of the suffering that some of these individuals experience. We support strong and appropriate procedural safeguards that would permit patients with mental health issues to access the law under certain strict and limited circumstances. These safeguards, including practice guidelines and standards for training, should be developed by clinicians and professional and regulatory bodies. In our view, these safeguards are not appropriately regulated through the prohibitions and penal sanctions of the Criminal Code. And just in closing, I would say in 2016, you'll remember well, the Senate recognized that the government's assistance that MAID should only be available to those Canadians whose death was reasonably foreseeable, flew in the face of the Carter decision and unconstitutional. We call on you once again to bravely recognize and uphold the rights and freedoms of all Canadians. Thank you.